I don't know. You guys probably saw Hope Hicks is was the communication director for the White House, and she is resigning. And the reason she's resigning, it sounds like, is because yesterday she was testifying in front of the House Intelligence Committee, and she told them that as part of her job, she was forced to tell white lies, but not any serious lies, just white lies, and that was part of the job, but no lies about Russia.
Hold on. I think this is important. Was she... I didn't get the impression she was forced to tell white lies. I got the impression that this is just something that she happened to do, tell white lies as a part of the job.
I thought that's not what I saw. What I saw was that I was forced to tell white lies.
So here's what the New York Times said. The New York Times said that Hope Hicks told the panel, the House Intelligence Committee, she had occasionally, quote, been required to tell white lies.
Oh.
There you go.
But had never lied about
Tom.
anything connected to the investigation into Russia's interference in the 2016 election. And when I say quote, I mean I'm quoting the text of the New York Times. That's not a quote from Hope Hicks.
Yep.
That's a quote from the New York Times. That's her words, not our words. No, that's their words. It's not our words. I don't have any words. These are just words.
So here's the deal, right? Can we now start a trending hashtag on Twitter that is hashtag white lies matter? Or is that inappropriate?
That's terrible. It's terrible. Oh, I'm embarrassed.
Oh,
So are we allowed to
good.
put that? Is that allowed to be on Twitter and potentially even on the show? Because I don't want to get lampooned. I don't want to get lampooned and saying that I don't want people to go around saying that I don't believe the Black Lives Matter because I made a joke about how white lies matter. You know what I mean? So I need a guarantee from the two of you as card-carrying members of Twitter, left, I've said it, AJ, Twitter, that I will not be lampooned for this. I don't want to end up like some of these other people that were just making a joke, and then it gets taken out of context.
They're a roving mob that just move from one outrage cycle to the next. Like, I can't guarantee what they're going to get mad about.
I think...
Dude, I can't believe you did this, Tom.
What?
You
Calm
just
down.
tweeted it out there?
Yeah.
I came up with that joke myself.
Hope Hicks lasted approximately 19.6 Scaramucci's as communications director.
Tom, can you tweet that out? That's legit. That's good stuff too.
Someone
and
did
then don't
tweet
forget.
it out.
Oh, can you retweet it, but then put hashtag White Lives Matter? Maybe we can get some more listeners this way. You know. So one other thing that I promised to do on the show is so some of our listeners, it seems, have complained to my fellow co-hosts that
Is this follow-up?
is this considered follow-up? Shouldn't we put it at the end?
I love that
AJ?
Rich's follow-up goes at the top of the show and my follow-up goes at the end of the show.
So our listeners, one of our listeners wrote in and said that she seemed a little peeved that I was not listening to our show, and that I was, I guess, deriding Trump style people that do listen to the show. I want to make it clear. I don't think that's what I meant, but I don't listen to the show, so I'm not sure if that's how it sounded.
And you think everyone who does listen to the show is an idiot?
No. I'm not Michael Savage. Okay. I think our audience is a bunch of sophisticated people that come to our show for quality entertainment, quality content, and to learn a thing or two. You know what I mean? And I think we do our job every week, and that we've been doing now for what episode number is this now? Are we 49?
49.
I love our listeners. You know what I mean? And it warms my heart when they tweet us. You know.
So what are we doing today?
I think we have a lot of legal stuff to talk about.
Oh, no thanks.
Yeah. Oh yeah. This is good stuff. So do we want to talk about this unions case? Is that where we want to start? Do we want to start, or do we want to start with the Supreme Court decisions where the court was wrong and we were right? Because as I understand it, the court disagreed with us.
To be fair, the court disagreed with you mostly.
Yeah. All right, here's what I think. Unions, follow-up, Supreme Court predictions, sidebars.
Shouldn't we start with the follow-up? I thought we were going to do go back to the past and talk about it.
I'm dying. I just died.
I say we just do whatever makes AJ, let's call it miserable, but I don't want him to actually be like fully miserable, just enough to
You don't want him to put his headphones off and leave.
Yeah, that's why we're not talking about Bitcoin yet.
As he's done in past episodes.
I got a hard stop at 9:00. Unions. Let's do unions. Okay, so the Supreme Court is hearing a case. It's called Janus against AFSCME. I probably pronounced it wrong. It's probably like Janus or something. But in James Bond GoldenEye, it's pronounced Janus. So the oral arguments went badly in that I think some of the justices are trash.
Care to expound?
Well, I don't like the conservative ones, but I do like the liberal ones.
So this is about public sector unions, right? So AJ, do you want to disclose your love of public sector unions now, or do you want to wait?
For the next month, I'll be a member of a public sector union.
Why are you quitting your union?
Well, I'm quitting my job.
So why are you quitting your union? Like, if you really love the union.
Well, because I'm going from a job that's covered by a union to a job that's not covered by a union. Actually, one of the things I'm saddest about is leaving my union. I actually really like my union. I think my union does a good job.
Why don't you start a new union and affiliate it with your old union?
I think that's protected under the law. I could do that.
You should start a union, dude. You should unionize. I think you can't really love unions if you're not willing to unionize. Do you know what I mean?
That may be accurate.
Can someone tell us the basic facts of this case?
Okay, so Janus against AFSCME. So the question up once again is whether public sector unions can require agency fees from public employees that are not union members. So to give some background, here's how this works. You have in Illinois, you've got a bunch of state employees that are covered by a union, and not all of the employees are members of the union, but Illinois has said, here is a union that is the exclusive bargainer in this field with this with this government agency, and the only union that bargains collectively on behalf of these workers is one union. Everybody benefits from the exclusive bargaining rights. There are interests to the state in having an exclusive bargaining partner. It solves collective action problems to the employees to have an exclusive bargaining representative. And so the question is, can employees who are not members of the union and may disagree with the union's political positions, can they be required to pay to fund union activities? And the very, very short answer, if you ask anyone who cares about precedent, is yes. But nevertheless, we find ourselves here.
Hold on. Could you restate the question one more time?
Can employees who may or may not agree with the political activities of the union, can they be required to contribute financially to the union's activities?
Mm-hmm.
And the challenge is a First Amendment challenge, right? The idea is that these union contributions are compelled speech that violate the speech rights of these public employees.
So, AJ, let me ask you this. So my understanding in reading some of the background materials was that current law does not allow unions to mandatorily get members to pay for the lobbying activities that the union does, or the sort of strictly political activities, but does allow union contracts, public sector union contracts, to include that all employees mandatorily pay any fees for, non-political activities. I thought that distinction already existed in law.
That distinction was created by a precedent that goes back to 1977, 1974. Let me look this up real quick. But it's a case called Abood. 1977. In Abood, the court found unanimously so this is practically the same fact scenario. It it's basically the same fact scenario as Janus, the case we're dealing with now. It's called Abood from 1977. And all 9 justices unanimously agreed that public sector employees can't be required to fund the political activities of a union under the First Amendment. But 6 out of the 9 justices voted to uphold the exclusive agency shop law. So the idea that there's one union that represents all the employees, that union collects agency fees from all the employees. That structure was upheld. And the 6 justices said that the way to make it work is that the union has to separate out the political spending and the spending on, grievance arbitration and on grievance arbitration and collective bargaining, et cetera, like the core union activities. That money needs to be separated out. And as long as they're not spending agency fees on like lobbying or candidate endorsement or whatever, then that's fine. And so that's been the long-standing precedent for 41 years now.
Okay, so just so our listeners kind of understand this, and more importantly, so I understand this, there is already law that says the political activities of the union cannot be charged to the members on a mandatory basis.
To the non-members.
To the non-members on a mandatory basis.
So just to define our terms a little bit, agency fees describe the fees that are paid by non-members to the union. Member fees are paid by union members to the union, right? So if you're not a union member and you're not paying union dues, then you have to pay agency fees instead. And the agency fees are equal to the union dues. So everybody's paying the same amount of money, whether or not they're a member. Okay, go on.
Okay, but no. So just to be clear, though, the members are paying extra for the political activities, but non-members are ostensibly not paying that money, correct?
They're not paying extra. So well, I mean, they can pay extra if they want to, but generally, agency fees are equal to member dues. So everybody's paying the same amount of money.
So is there an actual? Then how do you get the kind of Chinese wall? To pardon the phrase, I guess.
You can't use that phrase.
Oh shit!
You can't use that phrase.
This is worse than the White Lives Matter. Oh my gosh.
Okay.
Now I'm going to be.
How do you separate it out? So the union knows how much money it takes in, and it knows how much money it spends, right? So it knows how much it takes in member dues, it knows how much it takes in agency fees, and it knows how much it takes in from other sources. And as long as the member dues and the other sources add up to more than the political spending, then it's fine. And to be clear, at least from the oral argument transcript in Janus, the case currently before the Supreme Court, in that transcript, it makes it very clear that the vast majority of union expenditures go towards collective bargaining and grievance arbitration, and the kind of core union activities that the Abood precedent says is fine to fund using agency fees.
So what percentage of the agency fees, go to political activity? Like, does any of the agency fee go to political activity?
So here's sort of the disagreement in the case. So there are folks who want to overturn the Abood holding and say that you can't have agency fees in public sector unions.
At all.
And
okay, so that's one position.
So, and their argument is that it's all political. Everything the union does is political. Everything the union does has some sort of political effect, and therefore 100% of the expenditures go towards political activity. And that means some of the agency agency fees go to political expenditures. And so therefore the Abood holding isn't workable in practical application.
So right now then, so the argument of the folks that think agency fees are violate the First Amendment, because that's what this is. This is a First Amendment challenge, right?
Right.
The idea is that by forcing me, so I'm a public employee, as many people may know, and I don't believe I'm a member of the union.
You should join.
At least I don't remember signing up, so I don't think I am a member of the union.
You're a free rider.
The argument would be, sure. The argument would be that if you force me to pay these agency fees, what you're effectively doing is you're forcing me to sort of contribute towards speech that the union is making. And the speech in this situation, even a narrowly or a wide definition of speech, would include when the union says, hey, you, the legislature, should really increase Ruchit's increase the retirement contribution, for example, right? Or you should not lower the retirement or not change retirement benefits. Let's put it that way, right? You promise certain retirement benefits, just keep those promises. So when the union goes and negotiates with the legislature or negotiates with someone, forget advocacy before the legislature for a moment, but when the union goes and negotiates with my employer, that is speech, right? Isn't that the argument? I know you disagree with that argument, but that is the argument they're making, right?
Yeah.
And so they're saying the reason it's speech, as I understand it, is because, it has an impact on the state budget, right? So the decision to not reduce my retirement benefits has budgetary impact. So in that sense, it is political activity. It would be their argument.
Yeah.
So why is that wrong, I guess?
Two things. So first, there's a long line of Supreme Court precedent holding that it is pretty clear that the government has the ability to curtail its employee speech rights in employment matters, right? So in contexts that are, in contexts where the government is acting as an employer, right? It has managerial prerogatives. It has workplace prerogatives as an employer of people, right? They don't have to make the workplace, for example, a content neutral speech forum, right? So, if one of the examples from oral argument is that, you've got the Solicitor General of Illinois arguing in favor of Illinois' law. And Justice Roberts asks, are you come here to oral argument today? Are you allowed to say whatever you want? And the answer is obviously no, right? The lawyer responds, no, my boss is sitting right behind me. He has told me what to say. And, the things that I'm saying here, I agree with them. I think they're right. But, the government has ultimately the right to tell me what I'm allowed to come up here and say during oral argument, because it is directly tied to my employment as the Solicitor General, right? And so I think the first thing that's clear is that Abood says that these agency fees are serious issues that definitely are affected by the First Amendment, right? You need to have a very serious First Amendment inquiry when examining agency fees. But the way that shakes out is that the government has clear interests as an employer in, having a well-funded bargaining partner when it goes out to conduct these collective bargaining activities. And that interest permits them permits the government to trump whatever speech rights may be impacted by agency law fees. So that's the first thing, right? The core Abood holding and the core holding and the government as an employer is that, speech rights don't really work the way you expect them to in a government employment context. The second thing is that, the collective bargaining is something that, is something that is protected. I mean, it's something that we have protected as a policy prerogative for over 100 years in this country, right? That the collective organization of of employees, either public or private employees, to collectively bargain is a protected right. And it's something that is enshrined in labor relations in all sorts of jurisdictions. And so when employees collectively bargain for wages or workplace conditions, et cetera, right? When they bargained through their official organized representative, right? That's not political activity, right? That's workplace bargaining, right? The government is working as an employer, right? And it is having employment negotiations with the negotiating representative of the employees, right? So the conservatives on the court have this idea that, it impacts the public fisc or it impacts the policies of the government and therefore this is political advocacy. And that's just not true, right? Like if the government gets to curtail your speech rights as an employer in an employment context because of its managerial prerogative, then then it can team up with a third party to
curtail your speech rights, or to make you do speech?
No, if the government can curtail your speech rights, right, in an employment context, right?
What do you think about the difference between curtailing? So two things. One, what do you think about the difference between curtailing speech rights versus forcing speech? Because the non-union members here argue that, you know, by making them pay the $40 a month, which I think is what the issue is in this case, or maybe it's $40 every 2 weeks, that the government is compelling them to speak, right? Because as a condition of their employment, they have to, you know, pay these dues to this third party, which then uses it to speak. So that hold on a sec. That's the first question. Second question is, what about? So yeah, the first question was the difference between compelling speech versus not. Second, does it matter if the government is, so the government might not be able to make you do something, or the government could limit your speech in some regard, but can they then partner with a third party to limit or, compel you to speak?
Okay, so three things. So one, Abood already recognizes that agency fees impact your speech rights, right? So, you know, like this is compelled speech or whatever, like do you have to think about it differently? And the answer is that, like, Abood already thought about it through the speech lens, right? Like, you already have precedent that multiple states have relied on. There's serious reliance in over 30 jurisdictions on the Abood holding. The Abood already analyzed it in the lens of compelled speech. So that's not like a novel argument, right? That's something that there's already 40-year-old precedent on in that specific question. Second thing,
sure, but they can, but hold on a sec, AJ. They could revisit that, right? Like, courts regularly revisit, you know, even 40-year-old precedents. So
yeah, but when it's
we can't just say 40.
It's not warranted here, right?
Well, sure, but that's what the argument I'm asking you to make. Not to say, hey, Abood already said it was okay, but rather to say, okay.
Yeah. So I'm about to get to that.
Can I add something?
I had three things and I got through one thing. Hold on, Tom. I'm going to finish. Okay. Second thing out of three things. Second thing, there's a strong line of precedent that in the government's managerial prerogatives allow it to curtail speech rights, and so it can curtail speech rights in forcing you to preach the government's message as well, right? Like, you know, if you are a spokesman for a government agency, you have to provide the government's message when you deliver press releases, et cetera, right? So it's already clear that the government can compel speech, right? So should the government be able to compel this speech, the speech at issue, right?
But
so
that's not political speech necessarily, is it?
It can. I mean, it can be.
Like,
right?
So okay, so maybe in the narrow situation of a somebody who's doing PR for the government, right? But what about, like, just to, you know, somebody who's a janitor, right? Like, can the government say, like, hey, as part of your speech, as part of your being a government employee, you know, you need to go and if in the evening when you're cleaning you see any employees walking around, you need to tell them about how abortion is bad. Like, that's part of your speech.
No, because that is not the managerial context, right? There's no managerial prerogative in that context. It's not central to the job duties, right? Like, this is covered in the precedent.
So why is paying union dues central to the job duties? Like, why does paying those union dues or not paying union dues make you a better or worse janitor?
Okay, so that was the third point I was going to make, right? The impact on speech here is very minor relative to the extraordinary benefits provided by having peaceful labor relations, right? So the Abood precedent goes through all of the benefits that the government says are provided by having not just an exclusive union representation for its employees, but also for having a well-funded and competent union representative, and for eliminating the free rider problem, right? So the free rider problem is that even people who agree with the union, if they know they're going to be represented and have access to grievance arbitration, et cetera, without having to actually pay dues, right? If they could be a free rider, then why wouldn't they, right? So what the Abood recognized is that they deferred to the state legislatures and to the federal legislature and said, you know, there is a legislative finding that, you know, the state derives serious benefits in its managerial, in a managerial context from having an exclusive representative that is well-funded and well-organized, right? And also, we have all sorts of other contexts where people don't want to pay money for stuff they don't like. And the Supreme Court says tough luck, right? Like when people protest paying income taxes because they don't want to fund the war in Vietnam or the war in Iraq or whatever, the Supreme Court has said, who cares? Like the attenuation between you paying your taxes and that money ultimately being used for things that you don't like is like...
I think that's a little bit different, right? I mean, I think that's a little bit different, right? Because
so taxes into the Vietnam War is like more attenuated than agency fees into union advocacy. But I think that attenuation is like incredibly important, right? It's like less attenuated, but it's attenuated enough that the government's interest in having a well-funded union to negotiate with trumps the other considerations. Yeah.
Let me ask you this. Okay, so that sounds kind of absurd. Okay, and let me kind of explain why. To me, anyway, it sounds kind of absurd. It sounds absurd to me that the government wants a well-funded union to negotiate with, because that's like saying, that's sort of like Tom saying, you know, I'm a plaintiff's lawyer. I really love it when there's a well-funded defense lawyer. You know, or better yet, a defense lawyer saying, man, I really want a well-funded plaintiff's lawyer. Because, you know, when there's a well-funded plaintiff's lawyer, you know, we just get to justice quicker. Okay?
You say that, but, you know, just today, my law partner and I were talking about how much better it is to have a really good defense lawyer on the other side because it makes you a better lawyer. I mean, literally today, that's what we were saying.
Yes, but what I'm trying to say is that... But,
Ruchit, I understand your complaint, and I think, like... You know, it's sort of a legal fiction to say the government's compelling interest is a well-funded,
it doesn't have to be a
person to
interest.
Negotiating or whatever interest, right?
Right?
Like the government's legitimate interest is a well-funded negotiating partner. In reality, I think you know that's the legal fiction, but the legal fiction translates into I guess, real fact in the sense that the government is not just the government itself, right? The government is a government of people. The government is a government of public sector employees, and public sector employees benefit when the government has a well-funded adversary.
So yes, but remember, the government is actually all of the people, not just the public employees.
Sure.
Right?
Sure.
So
but
it's not clear to me that all of the people benefit when there's a well-funded adversary.
Okay, but you know the government doesn't make if you look at every decision the government makes, it's not as if every single decision benefits every single person in the United States or in Texas for the Texas government, right? The government makes decisions that it believes will have generally good effects either for a specific group of people in some certain cases or overall more good than bad. That's at least the goal, right? Sometimes they fail at that, but that's supposedly what they're trying to do.
Sure. The goal is overall more good than bad.
Right.
I would certainly agree with that.
And you know it is acceptable in our society to have a government that provides benefits for specific groups of people too. Right? Not that we know when the government makes this decision, it is making it specifically for folks that are handicapped and only that group of people, not anyone else in society. Right? And we don't say, you know what, the government is making that decision and they shouldn't because, yeah, it benefits the handicapped folks, but it doesn't benefit the rest of society. Therefore, that's an invalid goal of the government.
So here's what the court said in Abood. Quote, the principle of exclusive union representation, which underlies the National Labor Relations Act, is a central element in the congressional structuring of industrial relations. The designation of a single representative avoids confusion that would result from attempting to enforce two or more agreements specifying different terms and conditions of employment. It prevents inter-union rivalries from creating dissension within the workforce and eliminating the advantages to the employee of collectivization. It also frees the employer from the possibility of facing conflicting demands from different unions. Right. So that is why it's important to have an exclusive bargaining partner. Right. And once you have an exclusive bargaining partner, you have a free rider problem. And it could cause the union to not have the funding it needs to fulfill its institutional role. And so the court said in Abood that the government has an interest in having an organized, competent negotiating partner to make sure that the collective bargaining process goes well. But also, unions provide other functions than just collective bargaining, right? So there's grievance arbitration, right? So when an employee has a grievance against the managers, the union will provide grievance arbitration. And that's that's a useful function in industrial relations, right? So it's not just that, it seems crazy to me that the state would want to have a worthy adversary as a negotiating partner, but the union participates in harmonious workplace relationships. I know this is weird to us because we live in Texas where this is not the case, right? Like I'm even a member of the union of my workplace, and I don't think that there's any sort of grievance arbitration process for me to resort to at my union. But the point I'm making is that, the court generally is deferential to these sort of legislative findings, right? Like if the legislature really believes that it benefits it to have a competent negotiating partner, I don't know that the court really, even in a First Amendment context, should overstep those boundaries.
Do you believe that what the union is doing is political speech? I guess that's sort of a threshold question, right? In many ways, because if you don't think that, so when the union bargains on your behalf, right, or on the behalf of a non-member, as is the situation here, and they charge you for that, are they engaging in political speech?
No. I mean, I don't think grievance arbitration is political speech, and I don't think that collective bargaining is political speech.
Okay. So if the union says don't...
I think it's speech, but I don't think it's the sort of political speech that Abood says you can't use agency fees for.
So forget Abood for a moment. Do you think it's political speech or not, I guess?
No.
So you think it's not, right? Okay.
Yeah. Do you think so? What do you think, Ruch?
Honestly, I'm on the fence, Tom.
Mm-hmm. Well, let me ask you this.
I'm persuaded by both sides. So I don't know yet. You could almost think of me as a never mind, I'm not going to say that. I was about to say you could think of me as a Neil Gorsuch, but then I was like, why would I want to compare myself to that idiot?
I'm going to cut that from the show.
Oh.
Yeah.
If you think that what the union is doing in terms of bargaining is political speech, what about what state bars do on behalf of lawyers?
So the state bar issue is a little bit different, right? Because one, there's a statute that says that in order to be a lawyer, you have to be a member of the State Bar of Texas, right? Isn't that true?
I mean, there's a statute that says in order to be like a janitor, you have to be a member of the union, right? The reason...
Yeah, I guess that's true. Yeah, no, I guess that's true. Good point.
Rich, to help you out of the hole you just dug, the liberal justices think it's the same. Like the liberal justices don't think agency fees are any different from bar dues.
Yeah. Well, and there was a case in 1990, Keller v. State Bar of California, where the Supreme Court held that a state bar couldn't do any political or ideological activities. So, for example, if the vast majority of lawyers don't think that tort reform is a great idea, right? And so, as a state bar who represents the vast majority of lawyers, if they wanted to go and campaign or to advocate or to lobby the legislature, saying, "Hey, we represent all the lawyers in the state, and we think that this policy is a bad idea," they can't do that under this Keller v. State Bar of California precedent, right? So the way the state bars have gotten by is they're saying, look, the vast majority of our activities are non-political. All we're doing is, advocating on behalf of very benign needs of our members, right? But if you define things like negotiating, for benefits, what's the difference between that and the state bar going to the legislature and saying, lawyers should have this type of regulation, or the sunset shouldn't be, like the sunset negotiations? Wouldn't that be political too?
Yeah, it would be, but the state bar is not a union, yeah?
No, it's not. It's not. But
so hold on, right? The analogy works much better than you think, Ruchit, right? So the government is compelling you, in order to participate in your occupation, to pay fees to an organization that can conduct or make representations that you disagree with.
Yeah, I mean, that's true. I mean, I would agree with you. I don't know. I mean, I'm the wrong person to ask about this, because I think, generally speaking, state bars and all of these sort of quasi-regulatory, or sort of not, these quasi-public agencies are too powerful. So I don't know.
Really, you think the state bar is too powerful?
Yeah, I think all of these like licensing agencies are a little too powerful. Like, I mean, I don't know. It's hard for me to say that the state bar is like totally okay, but then, like the random agency that, licenses family and health therapists is not, you know what I mean? Or that licenses barbers is not, for that matter, I don't know.
I mean, do you really think that the state bar and the or agency that licenses barbers, I don't even know if that's a real thing, but let's just say it is. Do you think those two are analogous? Like in
No, I mean, not really, Tom. I take your point, I guess. I take your point on that. I think as a broad measure, maybe the state bar is a bad example here, but, I think a lot of these agencies that are set up in the name of consumer protection are really just protectionist. You know what I mean? So, these occupational licensing fees.
That's something you can make on a case by case. You can decide that individually.
Fair enough.
I think
I'm torn.
I think it's difficult to draw like a broad, to paint with a broad brush on that front.
I think you're right about that. I think broadly speaking, or not broadly, but specifically on this case, I'm still a little bit torn because to me, it really does come down to that kind of threshold question of like, is this political speech or is it not political speech? And I think that, in a lot of these negotiations, the fiscal impact is one good, what is political speech, what is speech, but in a lot of instances, arguments about how the taxpayer dollars should be used. You know what I mean? It's not, a lot of what counts as political speech is really about how do we use the money of the taxpayers? Do we use it to, fund healthcare? Do we use it to, fund the military? Do we raise taxes? Do we lower taxes? Just how do we divide up financial resources?
I think it's grossly unfair that the government can curtail employee speech rights in a managerial context, but that the employees, the employees' bargaining representatives, when they try to do the exact same stuff, that's considered political speech, right? So when the manager, when some sort of mid-level manager at a government agency goes to an employee and says, I don't think we can give you a bonus because there isn't money in the budget, right? That's a managerial context in the relationship. But when that employee's representative comes back and says, actually, we really think we should have bonuses this year, that's political speech.
Well, hold on. It's first of all, the threshold issue is, even before the speech issue, is that it's not the employee's representative. The employee has not hired this person to be their representative.
It is statutorily. It is the employee's statutorily mandated exclusive bargaining representative.
Yeah, but the employee hasn't opted into this. Do you know what I mean? The employee hasn't.
But it's still the employee's representative.
Yeah, but that's just based on a law that, we're arguing about whether it's constitutional or not. So I think the point is that it would be one thing if the state was saying, hey, you cannot have the person you chose to be your representative, charge you a fee to debate with us or to collectively bargain with us. It's one thing to say that versus, hey, there's this person that you have not opted in to pay anything or to be your representative, but we're going to charge you anyway.
But that's not addressing my point, right? Let's say I am a union member, right? Let's take your rejoinder away. I'm a union member. I support the union message. I willingly pay union dues. I carry my card with me in my wallet, right? How come when my boss says to me that I can't have a bonus, that's managerial conduct? But when my representative says to my boss that I deserve a bonus, that is political speech.
Well, one, they're not the manager, I guess, so that's one thing. They're an organization that's, but I guess the point is they're allowed to negotiate on your behalf. There's nothing preventing them from doing that. There's nothing preventing them from collecting a fee that you voluntarily pay.
No, I don't think you're understanding my question, right? So let me phrase it slightly differently. My boss comes to me and says, we're giving out raises to someone who wants to be the next spokesman, but by the way, the next spokesman is going to have to say, items X, Y, and Z out loud to the press, right?
Okay,
right. Like the agency manager can predicate my pay on the speech that I want to make, and that is a managerial context, right? Like they can say, we're going to infringe on your speech. You have to deliver this specific message, but we'll give you tons of money to do it, and that is protected. That is not a violation of the First Amendment. That is protected managerial conduct on behalf of the government. But if my union came back and said, you know what, we think you should pay AJ that amount of money, but don't make him do that speech, that is political speech. Like, why is that fair? Why is it fair for the government when they predicate, when they infringe on speech rights in the managerial context, that's fine. But when my representative that I willingly joined, I'm a voluntary union member, and I pay member dues, I don't pay agency fees, and I carry the union card around in my wallet. How come my representative, in rejoining that, in negotiating against that, how come that's political speech? Right? My manager can tell me stuff, and that's the government acting in a managerial context. But when my representative responds on my behalf, that's political speech. Why is there an asymmetry there?
I guess I'm not seeing an asymmetry because your representative is allowed to do that. Nobody's saying that they're not, because it's all on an opt-in basis.
But it's not a question of whether. But it's not a question of whether it's
what's
he's
the harm,
allowed to. Hold on.
What's the harm? Where's the harm?
But Ruch, it's not a question of harm. It's not a question of whether he's allowed to or not. It's a question of the characterization of the speech. Why is one speech characterized differently than the other?
Yeah, that's my question. Right? Why is the exact same speech characterized one way or the other, depending on whether the union is saying it or the state agency manager is saying it? The exact same speech.
I mean, that's a good question. I don't think I have an answer for you there. I think that's a good question.
Tom did a much better job of explaining it than I did.
That's okay. That's why there's three of us.
Ugh, I hate Tom.
I think that's the best argument that I guess I've heard. So honestly, I don't know the answer. And if we have listeners that are like, "Oh my God, you're an idiot. There's an obvious answer. Why didn't you say this?" Tweet us.
To be fair, I think, "Oh my God, you're an idiot." There's an obvious answer, right? To me, the Abood holding is clearly very good, and the fact that conservatives keep trying over and over again to overturn it, I think, is sort of embarrassing. Actually, the Abood holding would have been overturned last year, except that Scalia died, and so the case came out 4-4, and so conservatives just tried again with a different case, and it's going to be 5-4 because Gorsuch is going to vote with the same 4 conservatives that voted to reverse the Abood holding. So I mean, it's effectively as good as gone. Anyway,
so Breyer had a good proposal that I think I could get on board for. Did you see Breyer's proposal, AJ?
I think Breyer's proposal was basically Abood. Breyer does this a lot, where he takes something that someone else said. When someone else says something that's perfectly reasonable, but you're inclined to disagree because of their political affiliation, Breyer will just say the same thing again, slightly differently. And you're like, "Oh man, that sounds so reasonable," and then you're like, "Oh, that's Abood." Anyway, go on. That's
a talent, dude. That's a talent. So what Breyer said is, hold on a sec. Let me try and pull this up. We'll have to cut these things out. Breyer basically proposed that the portions of the union fee that could arguably characterize this political be sort of separated from the parts that were truly collective bargaining or, some of these dispute resolution things, et cetera, et cetera. And said, let's just divide those things out so that nobody can make an argument.
That's Abood.
That there's... Is it, though?
That's the holding of Abood.
Well, then maybe you're right about what Breyer said. I don't know. That seemed somewhat...
Okay, here's what they said in Abood. Listen to this. This is Abood, pages 235 and 236. We do not hold that a union cannot constitutionally spend funds for the expression of political views on behalf of political candidates or towards the advancement of other ideological causes. Rather, the Constitution requires only that such expenditures be financed from charges, dues, or assessments paid by employees who do not object to advancing those ideas and who are not coerced into doing so against their will by threat of loss of government employment. Right? So the core, right, what Abood says is that the unions can still do political organizing, but they can't use agency fees to do it. They have to use member dues. That's basically what Breyer said.
Breyer suggested non-members would only be required to cover the costs incurred for public sector unions by carrying out the duties that they are obligated by state law to perform. For Breyer, this would mean costs related to wages, hours, and working conditions, which shouldn't be hard to administer and should keep the things like lobbying and so forth out of it.
Yeah.
Is that your understanding of Abood?
Yeah. Yeah, that's what I'm saying. Breyer has this amazing talent for taking this thing that people have a political predisposition to agree with it, and he just restates the existing thing in a way that makes it sound very reasonable.
Dude, Breyer's a magician. You should love Breyer.
Okay, there's one other interesting exchange in the oral argument transcript that I wanted to bring to everyone's attention. So there's an exchange between Sotomayor and the Solicitor General. So Solicitor General Noel Francisco is Jeff Sessions' and Donald Trump's Solicitor General. The previous Justice Department under Obama, with Solicitor General Verrilli had argued that these agency fees are good and they're important in how the government conducts industrial relations. And so Sotomayor said to General Francisco, now that the Trump government has flip-flopped, taking the opposite view, she says, by the way, how many times this term have you already flipped positions from prior administrations? And Francisco says, I think we've revised the position in so far 3 cases. And I think it's interesting that Sotomayor sort of snapped at him about that. I do think that's important. So my understanding is that, it actually sort of does impact the credibility of the Solicitor General's office when they keep flip-flopping these positions. And the reason why is that, the court understands that this Solicitor General works for someone who works for the president and blah blah blah, and that things have political prerogatives, but they're supposed to be able to rely on the Solicitor General to weigh in on cases and provide the right answer, right? And so the Solicitor General's office may prioritize cases based on whether the right answer is in political alignment with the prerogatives of the administration, but I really do think that justices expect that the Solicitor General is going to help them figure out what it is they really need to be doing. Does that make sense?
Yeah. I mean, I think you're underselling what the sort of justices are capable of and can figure out on their own. So I think this I think you're right in a limited sense, in the sense that the justices are relying on that when it comes to things like matters of something that might affect the defense of the United States, let's say, right, or national security related issues where there should be continuity, in terms of what the government believes its powers are. I think it's another issue when you go into more kind of political questions, that there's a clear ideological difference, right? I have no doubt that if the situation were reversed, at least as it relates to this union case, that the SG's office, if it was Obama, wouldn't flip. You know what I mean? And I'm sure that there were examples where the SG's office did flip on matters of policy where there was definitely a disagreement. You know what I mean? Like, I'm sure there were regulatory issues in which the administration flipped, right? I think the greenhouse gas issues, so in the Bush administration, 2007, I think it was Massachusetts versus the EPA. The Bush administration argued that the EPA didn't have the authority or shouldn't have to regulate greenhouse gas emissions. And the Obama administration came in and, basically took the exact opposite position on all environmental issues and argued for the expansion of the administration's power when it came to environmental issues. So I don't know, man. To me, that's just sort of normal, what you would expect. I don't think that's a...
So I think that's generally
legitimate
right.
hit
I think
on the
you
SG's
expect the Solicitor General's office to flip in a limited number of circumstances, right? But
so
the surprise. I mean, just this term, right? Just this term alone. This term just started in October, right?
Yeah, but that's when it would be, right? I mean, it would have happened in this term.
No, I mean, the Trump presidency started in January, right? So it's just since from October to now. They flipped 3 times, right, in 4 months. But the Justice Kagan also expressed a lot of surprise at the government's position, right? So she said, "It strikes me as a very unusual position for the government to be taking, looking after the long-term interests of the United States government, because essentially what that means is that you will have to litigate all employee-employer disputes under the second step of Pickering rather than the first. Basically, the idea that if this really is speech and blah 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 blah, right? Then it's going to weaken the managerial prerogatives of the state, right? That all that line of precedent that the managerial prerogatives of the state trump the speech rights of employees in an employment context, right? Basically, I think what Kagan and Sotomayor are accusing Francisco of doing is trying to have it both ways, right? The exact same I was trying to talk to you about before, right? That the government wants to have it both ways, that, this is political speech when the people who are politically disfavored by the current administration do it, but it's not political speech when the U.S. Government does it, right? And I think that they really do think that the institution of Solicitor General's office is supposed to be above that sort of thing.
I don't know, dude. To me, this seems honestly not that different than on the environmental issues what the Obama administration did and what you would have expected them to do, right? you would have expected them to lobby for a more expansive power of the environmental regulator than the Bush administration did. You would expect them to turn on a dime on something like that.
But that was so what I read is that the Obama Solicitor General's office flip-flopped on basically two things. One of them to do with the due process rights of military detainees, and the other one to do with mass VPA, right? And that was it. I mean, there were two very clear cases that didn't. I mean, they didn't have the same sort of impact that Kagan is talking about.
I don't know about that.
Justice Kagan is talking about the long-term employment interests of the government, et cetera.
I mean, that's her opinion, right? I mean, that's a policy question that the government can decide. She's not the executive branch.
Right, but the previous Solicitor General's office had said that. Right, like I think Kagan and Sotomayor are annoyed at the Solicitor General's office for flip-flopping in a way that is not consistent with the long-standing practice of the SJC's office.
Yeah, I think that's a totally unfair criticism. And I think that Kagan of herself should probably know how unfair it is, in the sense that she became SG, for Obama after, whoever it was for Bush stepped down, when Bush, when the Republicans lost the White House and when Bush no longer was president. So I don't know. To me, I think that's that's a totally unfair.
I think you underestimate how much elites like Supreme Court justices are sort of enamored by the sort of weighty aspects of the institution, right? These sort of traditions and conduct and things like that.
I mean, listen, here's the deal. Kagan and Sotomayor do not agree with what the government is doing here, and that's fine. They can not agree with it, but the idea that they wouldn't have executed on that exact same type of flip if they were in the SG's office is just sort of belied by the facts. You know what I mean?
Well, you might be right.
This was a good discussion on this case, by the way. Do we want to predict what's going to happen? Should we do that?
It's going to be 5-4 against Illinois.
Yeah.
Yeah, I think it's going to be 5-4 as well. I wonder if Gorsuch can be persuaded by some of these sort of.
No, he can't.
Nah,
there's absolutely no chance of Gorsuch doing a good thing. Are you joking?
No, I think there's chances of him doing a good thing, but not related to this. And I'm still on the fence on whether I think this is a good thing or a bad thing. So,
all right, what else we got? I got 25 minutes.
So are you? Hold on. Are we all 5-4?
Yeah, I'm 5-4.
Janus.
Yeah.
Okay. Well, we won't even count this then. Let's do a Supreme Court prediction, and I want to start the Supreme Court prediction by forcing the two of you to listen to some audio and getting your reactions. So go to the Skype or the Slack and click the link that I just put in there.
Okay.
Hold on
and listen to the audio.
Should I splice this into the show?
Yes.
So what I would like you to do is to tell me what pages to look at in the preliminary transcript, which I have here, which will show that you did object, or at least that some of the compelled statements were used.
So none of this is in the record, and the reason it's not.
It may not be in the record,
but
if it's not
that's
in
an important point, isn't
yes.
it?
Of course it's an important point.
Well, before we start having an extended exchange about material and something that's not in the record, I guess I would just like to point out that it's not in the record. There's a reason we confine things to what's in the record, including how do we know what this is if it's not in the record? How do we know that it's been adequately had a chance for people to object to it and all that? It's not just a passing comment that it's not in the record.
Nor is actually mine a passing comment, because Article 3 of the Constitution says we are to take real cases and controversies and to decide a major matter where, in fact, going from what is in the record to an earlier stage of this and discovering, if it's true, that there was no instance about which you are complaining, in my mind, raises the question as to whether this is, in fact, an appropriate case or controversy for the court to take.
And we're supposed to decide whether the cases are controversies according to law. And as far as I'm concerned, coming in and saying, I want to know about this thing that's not in the record, is no difference from somebody else coming off the street and saying, hey, wait a minute, I know what happened in this case. So go ahead and answer. It's a question that you've been presented with. Go ahead and answer.
You don't have
I
to
want
answer
you to,
it.
No, feel free. I'm just saying I will discount the answers because it's not something that's in the record.
Yeah.
All right, I listened to it.
What'd you guys think?
Why are they so bickery? They're so bickering.
Yeah, isn't that crazy?
They should let her get in a word, huh? The attorney.
That was an exchange between Justice Breyer and Chief Justice Roberts in the city of Hayes v. Vogt, V-O-G-T. I don't know how you pronounce that, but I assume Vogt. But, it may seem a little mild-mannered, I guess, to lay folks, but I thought that was just a very heated argument, as if there was some beef between the two of them. Particularly at the end where Justice Roberts says, I'm not going to give it any credit. You can answer the question, but I'm not going to listen to it. It was very out of character for Roberts too. He's usually a mild-mannered kind of guy.
Yeah, he's pretty. He's pretty chill. Like he's got a, I wouldn't say a good poker face per se, but he definitely has. He can typically use humor to make a point as opposed to getting angry.
He's no Neil Gorsuch.
That's true. That's true. He's not universally loved by his colleagues.
So this case comes from Kansas, and the issue in this case is whether the Fifth Amendment is violated when a criminal defendant is compelled to incriminate himself, and the incriminating statement is used in a probable cause hearing rather than a criminal proceeding. So just to give you some background and kind of understand what the hell that means, Fifth Amendment obviously prohibits the government to force people to give testimony against themselves. In this case, Kansas introduced a compelled statement against the defendant in a preliminary hearing to determine whether the state had probable cause to pursue criminal charges against the defendant. So basically what happens is Vogt, V-O-G-T, says that his statement was compelled because due to this weird series of kind of unfortunate events, I guess. He works as a police officer in the city of Hayes, Kansas, and he applied to a job in the city of Hayesville, Kansas. During the interview, he, for some reason, revealed that he had kept a knife from his previous employer, the city of Hayes. Hayesville told him, you know what, we'll hire you, but if you want the new job, you have to go tell your old employer about this knife, that you took it, blah, 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 blah. Long story short, as a result of all of this exchange, he was charged with felony possession of this knife. And they used the statements that he gave to his employer, under threat of not getting this new job, as evidence against him in a preliminary hearing to determine whether or not to go forward and charge him with this, crime. The heart of this case is whether probable cause at a preliminary hearing, you can use unconstitutionally acquired evidence to charge a criminal defendant with a crime, right? And so it doesn't have anything to do with whether that is, whether you can use that against him in the trial necessarily, but whether you can use you can compel him to speak to bring the charges and then have leverage over him in that sense. The city
this is
argues
crazy. How has this not been decided yet? Like,
well, that's what the Supreme Court's for, to decide things like this.
But this is crazy. Like, how has it not been decided yet whether you can use fruit from the poisonous tree, if you will, so unconstitutionally obtained evidence in an indictment?
Yeah, well, it's not necessarily an indictment. It's the preliminary hearing to determine whether. So each state determines whether they're going to bring charges against a criminal defendant differently, right? Some states have a procedure where you just write out something and that's your charge against the defendant, right? In Kansas, they have this preliminary hearing to determine whether, look, does the prosecutor have probable cause to charge the criminal defendant with a crime, right? Some states, you call it the grand jury, whatever you want to call it, right? But in the issue here is whether in that proceeding the state can use unconstitutionally acquired evidence, specifically a compelled statement, to charge the defendant essentially with a crime, right? And the defendant is saying, well, you can't do that because if you use unconstitutionally acquired evidence to charge me with a crime, you get leverage over me, right? All of a sudden I'm facing, a trial, I'm facing these penalties, and so you have leverage over me, and that's not, constitutional to do that. The city's saying, well, it doesn't really matter because if all we have is unconstitutionally acquired evidence to charge him, then the defendant can just move to dismiss after he suppresses the evidence, right, at trial.
Right, that is true.
And the defendant, the defendant is saying, well, like the plain language is clear, blah 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 blah, that you can't do this.
This is super interesting.
Yeah. So it is an interesting and more complicated case than you would initially think, but and the other little wrinkle about this is that the case itself at the Supreme Court, the City of Hayes v. Vogt, is not a criminal case. It's actually so what happened was he was charged with felony possession of the knife, and it never went to trial because he got it dismissed. And so he sued the City of Hayes for their conduct in leading to this charge, and that's how it gets to the Supreme Court.
What do you guys think? What do you think? Predictions, AJ?
It's a tough call.
This is a tough one. So on the one hand, I certainly understand what the defendant is saying, or not the defendant, but the plaintiff, I guess, in this situation, the person who, was charged with the crime, that what's the point of allowing you to use evidence that is unconstitutional in the process of, getting an indictment? And as a result, can you use unconstitutional means to indict me effectively? Or, can you
Basically
use the fruit of the... Yeah, because if so, then you could really just harass people, right? I mean, you could do that. You could just find out. I mean, it would just be bad, it seems. And so what's the point? On the state side, I think I can understand or sympathize a little bit with the argument that, hey, sometimes, some of the evidence that we have may be unconstitutional, but we may also have other evidence that is not unconstitutional. And the whole point is not a constitutional question, because this isn't about whether or not we send this guy to jail. This is about whether or not we indict him,
Yeah.
And that's just a totally different question. That's why there's a different legal standard, probable cause, not, beyond a reasonable doubt. That's why it exists this way. It's a really, I guess when you first mentioned it, Tom, I was like, this is absurd. I'm totally with the guy who was charged with the crime. And now, as we've talked about it a little bit more, I'm definitely more on the fence.
Yeah, well, I mean, the argument for the criminal defendant is, look, you're saying that this is just a charge. This is not conviction of a crime, but being charged with a crime carries, stigma in society. You
have to disclose it on most job applications, for example.
Yeah, exactly, and it also is leverage that the state has over you in forcing you to plea, because most of these cases do end up in a plea.
True, that's true.
And of course, what the state responds is well, if you have a lawyer representing you, they're going to say, well, look, all the evidence is inadmissible, so don't plea. Let's move to suppress and get the case thrown out.
All right, I'm ready to predict.
Predict.
What's your prediction?
I think it is going to be 5-4 in favor of the defendant.
Oh.
Ruch?
I think it's going to be 7-2 in favor of the city. And I think the two dissenters are going to be Sotomayor and Kagan.
I think it's 5-4 city.
I just don't think it's going to be that close. I think it's going to be, as I said, it's either going to be like very clearly something you're not allowed to do or very clearly something that you are allowed to do. But I haven't listened to the oral arguments, so I don't know.
Yeah.
Okay, cool. What should we talk about next?
Sidebars?
Sure.
Oh,
Rich, what's your sidebar?
dude. Okay. So, my sidebar, if I've not used this sidebar before, and I might have. So if I have, that's just too bad for our listeners. They're gonna get it all the time again. My sidebar is Bill Gates' blog, gatesnotes.com. It's a really cool blog. Bill Gates is like a total optimist, and he is a welcome sort of change of perspective. And he doesn't really write about business per se. He really just writes about the books that he's reading and the work that his foundation is doing, and why him and his wife and his foundation are focused on the things that they're focused on, like public health and education and things like that. And it's interesting because I'm torn on Bill Gates. And by that, not about his business career, which I think for the most part was awesome, but what I'm torn on is his sort of kind of deliberate silence as it relates to the political issues of our time. He's a person with a tremendous amount of credibility, obviously. And he sort of said a bunch of things that makes it clear that he's not really, a fan of President Trump, but they've all been like he hasn't mentioned the man by name. Right. And so on that respect, I'm like, man, Bill, I wish you would speak up. But there's another part of me that says, hey, like Trump takes up all the energy, a lot of the energy, positive or negative, that exists in the world right now, some crazy percentage of it, I'm sure. And maybe we should have people that are highly respected, like Bill Gates, that basically say, listen, I'm not talking about that stuff. I'm going to talk about other stuff. And I don't know. I think that's but anyway, I think his blog, regardless of how you come down on that issue, if you care about that issue at all, I think his blog is really awesome. And it provides a perspective that I think we just don't really hear, because the news media doesn't really write about all the great things that are happening in the world, because there are legitimately, obviously, a lot of not great things that are happening in the world. So I would highly recommend it to you.
Yeah, it's good. He has some good books that he recommends.
Yep.
I'll go. My sidebar is a while back, John Oliver did on his show did a segment on coal. And that's going to link in the show notes, but that's not my sidebar. My sidebar is after John Oliver did this segment on coal, one of the coal barons that he discussed on his segment sued him for defamation. But that's not my sidebar either. My sidebar is that this lawsuit was recently dismissed, with prejudice against the coal baron. But even that's not my sidebar. My sidebar is this West Virginia ACLU amicus brief that was filed in the course of this litigation, right? And on John Oliver's behalf. And it's a great brief just to peruse, because they've got some great brief headings. For example, one of the headings in the brief is anyone can legally say eat shit Bob. Right, Bob is the first name of the coal baron, right? And so they've got this good theme going. They've got plaintiff's motion for a restraining order is ridiculous. Courts can't tell the media companies how to report Bob. And all of John Oliver's speech was protected by the First Amendment. You can't sue people for being mean to you, Bob. And plaintiff's requested injunction is clearly unconstitutional. You can't get a court to order how the press to cover stories, Bob. It's pretty funny because in the Cole segment, John Oliver compares this guy, this coal baron, to Dr. Evil, and one of the arguments that the ACLU makes is that truth is an absolute defense to defamation, which is true. And they have a picture of the coal baron next to the Dr. Evil. And this is on page 11. It's linked in the show notes. If you guys want to look at it I've linked to it in both the cloud and on Slack. Page 11. Take a look at this picture and you tell me whether truth is an absolute defense.
Oh my gosh. Oh, this is so good. This is so good.
Why is he holding his pinky like that?
He's trying to admit. I mean, isn't he admitting? I mean, you know.
And I'll include a photo in the show notes as well, so you can see for yourself.
Bob Murray thinks John Oliver was mean to him, and he doesn't want him to be mean again. While that is sad for Bob Murray, it is unconstitutional for a court to order such relief.
Yeah. I hope the ACLU comes to our bat when Bob sues us.
I've contributed to the ACLU on multiple occasions, so hopefully they'll have our back.
So that's my sidebar, AJ.
Bob, no. Before we go, oh my gosh, Bob Murray needs to be taught that our judicial system is simply not the place for harassment and petty grievances. Oh my gosh, can we please tweet or otherwise contact Jamie Lynn Crofts of the ACLU of West Virginia Foundation and interview her about this case? Because I think this would be hilarious.
I mean, we have her email, or his email. I don't know if it's a male or female.
Let us please do that, because I would love.
Why don't you do that, Ruch?
Oh God, Tom, I don't have time to listen to the show, contact potential show guests.
White lives matter, dude. White lives matter.
Jamie Lynn Crofts. Okay. Oh, nice. She's been featured on Above the Law. Dude, we got to interview her. We got to interview her. Tom, you need to contact her or tweet her or do something. She's on Twitter, dude.
Ruch, why don't you do that?
Dude, we have to do this. Tom, you got to tell her we talked about her in the show and that we would like to interview her.
No, I have 6 minutes. I'm going to do my sidebar.
She's awesome.
I've got 6 minutes.
Is awesome.
I'm going to do my sidebar. All right. Click on my sidebar. It's in the show notes. Do you want me to put it in the Slack?
Is this another video from some
Yeah, kind of. I mean, you can just read the article. You don't have to watch the video. So basically,
sorry, AJ, I shouldn't be so dismissive, but
Christopher Jobson at thisiscolossal.com/2017/12/Tetsuyo Horiyuchi Excel artist, and so forth. So Tatsuyo Horiyuchi is a Japanese artist. He has been making these shockingly, stunningly beautiful.
Oh, this is pretty cool.
Creations. And then it turns out that he doesn't use pastel. He doesn't use oil. He uses Microsoft Excel.
Whoa. Bill Gates needs to see this.
Yeah, isn't this amazing?
This is cool, AJ. This has to be the best thing you've made me watch on this show, which is granted a low bar, but this is extremely cool.
Yeah. But just look at the paintings. Look at the paintings and then look at the screenshots from Excel and how he makes them. Anyway, I encourage everyone to check the show notes. Go to heartlanded.com. You can look at the show notes and you can see these amazing works of art that Tatsuyo Horiyuchi makes using Microsoft Excel.
Dude.
Right? Isn't it good? This is a good sidebar. You were like, oh, blah, blah, blah. We got to get this woman on the show. And it turns out that actually I had a very good sidebar.
Dude. This is I'm sorry, dude. As good as that Excel art is, this ACLU brief is a 5,000 times better. Jamie Lynn Crofts, if you're listening to the show, or if Tom has actually done what I have requested and tweeted at you, please come on our show to talk about your brief and about this particular case, and kind of what compelled you to sort of write it this way, right? This would be an interesting episode, I think, on kind of it could be an interesting episode on brief writing. This is actually a fantastic brief, period. But the fact that it's fun to read and is really quite bold is interesting as well.
All right, I gotta go. Bye, everyone.
Tom, it's time to talk about Bitcoin.
You still have 3 minutes, AJ.
Oh, you know what we haven't done in a long time?
What?
Oh, we haven't done this in so long. Get ready. Are you ready?
Can you put this at the beginning of the show?
Oh my gosh.
Oh.
I can't believe you guys can't get through an ohm without talking. All right, I'm clicking off.